Good afternoon. I'm Chris MANGIARACINA. I had a career with the FBI that ended last year. I was a asset forfeiture and money laundering specialist here in Miami. The squad was dedicated to providing money laundering investigation services throughout the broad band of FBI violations. So it was customary for me to be involved in cases that expanded from Ponzi schemes to organized crime cases to counterterrorism, counterintelligence, public corruption, and usually the very large-scale ones. So that meant often, especially being in Miami, that I was assigned to some very large cases involved South American corruption, in some cases Italian organized crime abroad. So that's a little of my background. And before we get started, I just wanted to ask a question on who do you think does a better job at recovering assets, the civil, private endeavors, or the federal government? I thought I knew, but what do you say? Civil side. I'm only out 8 months, and I can already tell you the civil side does a much better job at it. You know, that being said, what I'm hoping to accomplish by surveying some cases, some of which I was involved with and some that I wasn't, which ones the government is better apt to deal with and can actually help even improve on the civil recoveries if they spend more time doing so. Another caveat, Greg Coleman thought that when I wrote government-assisted fraud, he thought I was talking about U.S. corruption. I'm not. I'm talking about foreign corruption, foreign government corruption. But saying that, I will start with a little anecdote. I worked the Vladimiro Montesinos case back over, oh gosh, almost 15 years ago now. I was coming back, actually I was going back to Lima on my second trip after having a lot of success working with various entities in Lima, including the Weissman Commission and magistrates and banking commissions. I got extensive bank records. So, and I'm coming back in amazement because some of the banking information and records that I was analyzing took me to an account in Dallas, Texas, Bank of America, and I was surprised to find out that that's actually an offshore account. It looked and read just like it was an account in Dallas, but it had every bit of protection as a Cayman Island account, which is what they're telling me it truly was, and it was sort of shrouded that way. So, and why am I picking on the United States that way, or at least the U.S. banking, is because what we're really trying to look at is that the definition of what an offshore bank is today is very, very cloudy. The distinctions that are made between what constitutes an offshore entity and what doesn't is growing more and more difficult to determine, as is the distinction between what a fraudster is and what a money launderer is, because the scale of money laundering now is being so centered by third-party money launderers that you can't trace the act of a particular fraud sometimes to the laundering that's being severely enhanced by government cooperation. So what I'd like to do is go through a number of cases very briefly. Some of them I had some involvement with, some I didn't, but they will kind of give you a feel for the success or lack thereof in different instances involving offshores in particular in actual recoveries. You know, the United States is very good at labeling huge amounts in judgments. They're very bad at following up and actually getting that money back to its victims. So the first one here, our host, David Marchant, was actually had some involvement with and covered the story. As he told you, his real name is Gilbert Allen Ziegler, operating in Grenada. No sooner did the Grenada allow for the creation of the banking creation that he went ahead and opened up his first international bank of Grenada. The word is that the real brains behind the whole thing was Douglas Ferguson. Again, shame on the investor for not knowing better, 300% interest. very textbook. And then, of course, huge amount of money. They were apprehended overseas. There was a shootout. I think a security guard was killed. And the FBI was frustrated in not being able to advance any investigations in Grenada that were stopped by the Prime Minister, who was determined to have some level of involvement. And then, and this is David, I'm quoting David, not actually from his own Offshore Alert, but from an interview that Christian Science Monitor had of his, indicating that there is absolutely no change there with no recovery. So this is just a classic example of what happens offshore, whether it involves corruption or offshore. When you're working overseas trying to make a recovery, this is usually the traditional outcome of the case. And you could see he never made it there, and everybody pled guilty. And as often the case is, they either blow their money or they lose it themselves and in this case by other conmen. That's according to the U.S. Attorney. So here's a case I have had some participation in while I was with the Bureau. It's an ongoing investigation involving Curaçao. It's a very delicate situation down there because of a number of different activities that are going on. So it's become very important to the United States. It's important to Netherlands proper. It involves a guy named ROBBIE dos Santos, who's been arrested, committed a fraud with lottery, counterfeiting lottery winnings. There's a lot of other things that were also involved in the case. You could see this half-brother got involved with the government, and not too long after Netherlands realized that there was a family connection to Dos Santos at a very high level of the government, they came up with this economic warning. You read between the lines, but I'm bringing it up because this is, again, grappling with a government-sponsored fraudster. You talk about what are some of the possibilities that you can do. This was a very not so subtle way of saying you better clean house or we're going to come back in my opinion, personal opinion, we're capable of coming back and claiming the island, okay? So after this occurred, this declaration was made. This is the portion that I had some connection with. We were prepared to take an action against the money that was located here in Miami out of a BVI account. And fortunately, Dick PR, who I know personally from another case, provided the action that we were hoping he would give us to allow us to work through the MLAT treaty and do it on their behalf as opposed to us coming in from the outside on the funds. Prime Minister Schotte, it became an expanded investigation. It was determined that again, this is an ongoing case, but this is all public information on what's being written about what's going on with the matter. The journalist who was covering the case shortly after the arrest, this is what happened to his car. It was torched right outside his house. And so there you go. And again, it's advancing another point that I'm going to try to make is that the involvement of journalists and bloggers are crucial in cases involving corruption, especially at the very beginning of the case. And it's very, very dangerous work, obviously. The next one, of course, everybody's familiar with. Stanford. It's an ongoing matter. The initial phases of the recoveries were very weak. In spite of his prison sentence, the scale, of course, we thought was enormous until Madoff came around. And you could see the amount of money that receivers had to take off the top, and so little money was available at that time, or what they thought they would be able to get, that they were trying to go after the government in terms of the money that it was provided directly by Stanford. Now, we had information, again, the United States has to take some responsibility, but I think there was something that we could have done at an earlier stage, and it's hard to say exactly what happened there, but we were very frustrated not being able to advance some intelligence that we had at an earlier stage. Obviously, it started with the Prime Minister, but it permeated throughout. In our opinion, it thwarted some actions that our own government was capable of doing and maybe should have done. So more recently, you have this year is the beginning of the clawbacks, and some of you may know better than I am what the status is of that right now. I've heard that there's already been over $1 billion recovered. I don't know if that's true, but that from what I'm reading, he's doing a good job of prevailing in his litigation as trustee against those who were the recipients of the high returns on the front end of the Ponzi. And now this is also a very recent case, and I kind of have an indirect involvement with this, not the case that's been making the big news, but another one that was in the background. Banco Privado de Andorra, it's kind of historic in a way that the United States has executed requests under the Patriot Act 311, basically to vacate the bank's access to the United States and to put out a similar warning. And effectively, under the recommendations of FinCEN, caused the shutdown of the bank and those who are running the bank to be facing charges to some level. It was announced as a historic event, and it really was an important factor. And I just want to share my own frustration with you as we advance the story, because I had my own action against the same bank. Mine paled in comparison to the ones who were associated with this. When you're looking at some of the largest money launderers in the world right here, that all had substantial, multiple billions of dollars that were running through this tiny little bank. Rafael Ramirez, of course, of PDVSA in Venezuela, Andrei Petrov, and Xiaoping of China. Venezuela was particularly egregious in providing passports, diplomatic passports to the guy in the middle. There was actually a convicted heroin dealer and cocaine dealer. Yeah, he had a diplomatic passport in Venezuela, was bringing in pouches of cash into the bank. Up until the time that the amounts were so large, they started to just have to wire it in. So this is the thing that really kills me, if you can just read through there. Directorate of Privileges and Immunities, can you believe such a thing? Neither can Scarface. So, Banco Privado de Andorra had a number of correspondents. These are three. I believe there was one other. I think it was Mellon, but I'm not positive. And I had co-written something called a Patriot Act 981K action, which was, speaking with Jack DeCliver at the Department of Justice, was third in line of 4 drafted Patriot Act 981K action. So what is that? This is an interesting thing to consider. What is the more damaging thing? Is it a 311 which shuts down a bank but doesn't recover any of the money, or the Patriot Act action that basically allows you to seize the funds out of the correspondent bank in the United States, whether or not you have a direct trace of your target into that bank? The way the bank recovers their money is by debiting the account of the account holder we're looking at overseas. So the sum I was looking at was very, very small, $4 million. But and of course Jack told me there was something pending that was much larger, and so I absolutely understand what happened. But what I wanted to draw into discussion is this is an amazingly powerful tool the government has, considering how it doesn't hold its own compared to civil actions and recovering money. This has an indirect impact on what civil actions can do. There are a lot of civil actions, I understand, are trying to get information out of correspondent banks. It's been litigated, and some have been dismissed as being outside outside the rules, or there's no case law guaranteeing it. But I think if 981K was used a little bit more frequently than it is very powerful. That I think the United States is doing its part in recovering money overseas more effectively. So, you know, in effect, what good is it if it's not really put into use? So here's the distinction. You can shut down the bank, remove the access through a 311, or you can get actual recoveries using 981K. Before you can use 981K, you first have to see whether there's a treaty with that country that you can exercise first. The fact that it takes a long time is not an excuse to move over to a 981K, but if you can find that there's some unnecessary and deliberate delays that are going on, you can reconsider an action there. I think this is an important example of a successful use of 981K, albeit it's just an offshore gaming company. What's interesting is that the bailiwick of Guernsey did provide assistance, but it still, because of the restrictions of the legal laws in Guernsey, wasn't able to affect any kind of treaty return of the monies with the action, but they forced a 981K against its correspondent, but they didn't stand in the way of it. They just said, these are the confines of what we're able to do for you, so they were cooperative as best as they could. But it goes to show you that to what extent is an offshore account necessarily outside the purview of the United States' hand if it really, really wanted to go after it. And that's one of the few times where it was actually utilized. So again, I really feel that, in my opinion, it's been underutilized. So why has it been underutilized? Okay, I'll tell you what he's saying. He's saying finance is a gun, politics is knowing when to pull the trigger. And so why does the United States always sit on this powerful weapon that it has? Well, there may be some very good reasons. There are things going on right now, not only just between what the Russians are doing and how they're moving money through Tor networks. They are reportedly building their own alternative to the SWIFT payment system, trying to line it up with a blockchain platform. And as much as what my former colleague had to say about Bitcoin, and he's not far off the mark, IBM is reportedly working with the Federal Reserve on building their own platform, again, to mainstream this new sort of payment system, or at least may put it under consideration. So I've been asking a lot of our colleagues, what their opinion is, and it's no question it's going to increase in usage until, again, the correspondent concept, will that be in effect if we actually did move to a different payment system? I think it still would come into play. And then there's this other issue, which is the underutilization or the combination of having greater understanding and awareness of what the FATF has done through the G20 and at the time G7. And basically the journalists can help everybody hold up to those regulations. So all our countries, including the United States, who pretend to be supportive of these things, they have to be held to practice in the exercise of all of these recommendations. There's many, many of them. The famous FATF 40. These things obviously do not occur, right? But they're things that are being identified. It is the first step. These things have to occur. There has to be major bodies, World Bank, UN, et cetera, have all come up with their own recommendations. And I think it's great calling everything out. The question is, what do we do with that once that's done? Are we actually moving with any distance as a group, or are we all just checking boxes as we're going on that? And I'm talking about the government. I'm talking about everybody's individual business interest privately, or your own client. But there's things that have to be done collectively to really make a dent. Just to give you a scan of all the different groupings of the FATF and similar FATF groupings that are there to address the problem. So the question is, everybody gets the problem, everybody knows the recommendations. The next step is to find another way to make everybody work closer together and to reconsider, come out and admit, the United States should admit, we're not as good as civil side private actions in certain respects. We're stronger in other events. Why don't we, I know this sounds weird, but we've actually had to do this, is find a way to work together even when we disagreed in major cases. You talk about too many cooks in the kitchen and the slowness of the government actions. There are situations where bringing in the civil side is to our advantage. Likewise, there's advantages for civil side to work with the government. Sometimes they have the first ability to put a halt, or they can reach things that they can. In the Rothstein case, I was able to get $16 million out of Morocco. We had no treaty. There was no way the civil side was going to do that, but in spite of that, we couldn't compare with what the trustee was able to, the receiver was able to recover. So here you go. This is just a long list. It's not meant for you to go over too much, but just to show you how much information's out there and acknowledgement of the barriers that are at hand. And the lack of creativity for me is a big one in terms of really thinking beyond that point of time. If there's a country that you can't get the transaction for, expand, like if you're taking pictures, just expand your bracket outwards on your timeline long and work both ways back into the problem, and then use the circumstantial evidence to fill in the blanks. And then the power of the blogs, I guess I omitted our previous speaker. He belongs on the list as well. And I'm sure there's many others you may be aware of, but they all play an incredible, important role in making, bringing to the forefront. Basically, they help force the government to take action, whether it's the United States or another government. They make it very difficult. The more everything is shared and spread out, the more important it is. And they help keep the mainstream press in line when they may be trying to underplay the importance of a particular story. So in Fodio, for instance, Alec Boyd, who I quoted at the opening, he's written extensively about the problems in Venezuela and very successfully and really embarrassing them quite much. And he's been, his apartment has been broken into. They've stolen his laptops. They put threatening photos in his jackets of him walking his kids to school. He had been followed for a long time. I'm only speaking of these things because he went ahead and published it on his website. But the exposure that the journalists are taking are very, very, very serious and very important. To me, if I was still a federal investigator, logic holds it, I'm going to be reading the blogs. I mean, it's an incredible source of intelligence as an investigator. So if you're a private investigator or otherwise, they're doing enough by putting this stuff out. Don't expect a phone call from them. You should be reading what they have to offer and running with the leads that they're generating for you. So there was this, something that developed between not only private civil actions, but government civil actions were butting heads with criminal forfeiture and civil forfeiture. It's civil fines and civil forfeiture. And it was the opinion of the civil side of the U.S. Attorney's Office that forfeiture monies never went to victims. At least the mechanism seemed to be a bit drawn out, forcing them to file petitions. So there was this invention, this hybrid, which allowed a very expedient way to transfer money that was forfeited in federal government cases so that victims had ready access to at the time of sentencing. So, this is called the restoration of funds, and it's something that we used in the Rothstein case. So there you go. So who's better at it? Well, again, when it came to both Madoff and Rothstein, they really paralleled each other in terms of there was serious arbitration and conflict over who had the rights to control the assets and move forward with them. The United States, of course, always uses the argument, well, you're giving an incredibly high percentage to the trustee, you're losing the victims, are never seeing it. Well, you know, this is a perfect example that didn't hurt the victims at all. Okay, they had 100% return in Rothstein, and I think in Madoff they've done very well, thanks to the clawbacks, obviously. But we did have to appeal in the 11th Circuit. We reached a settlement agreement, and there are reasons for that, because there were parties of the law firm that we were still under investigating, so we called into question who the receiver was really representing, you know, at that point in time. Basically, most of what we forfeited and turned over is now within trustees' hands, and it went to the victim. So this isn't an argument for one side or the other. There was certainly an example here, in spite of all the difficulties. There are strengths to the civil side, to the private sector, there's strengths to the government. And we're only beginning to, nobody ever looks at the possibility of them actually constructively and methodically building and working together instead of it's incidentally falling apart. In terms of both intelligence, of course, there's limitations in how that works, but I just think that we could be doing a whole lot better if we put the egos aside and instead of the headlines, and you can see victims are going to fare much better if you wind up working together. There are a lot of cases that I worked where I came very close to forfeiting things, and there were certain reasons why the U.S. Attorney's Office didn't want to, or because of time constraints, or because as part of the plea had to remove certain charges that I needed to be in there to forfeit the things that I found overseas. Well, they were handed right over to the receiver or to the private, and you know what, I'm just glad. I mean, at least the bad guy didn't get the money, and the victim was going to get it. So, you know, those are my lessons from the time that I was, you know, working large profile cases. That there's a way to do it. It's not about who's better, you know, ultimately. And most of the agents will say, look, I don't really care. I just want the victim to get the money back. Or I don't want the bad guy to get the money back, let's put it, that's for sure. And then there's the other issues that, you know, these are all parties to going after the money, or things to consider as to what the best mechanism is. And just think of it as you know, as ingredients in your kitchen. You know, every case you may want a different combination, or have to consider certain elements of this to put together for how you're going to approach your case. I hate dry judgments, you know. I think that just is so disingenuous on behalf of the United States to say that it's done something major by throwing in this like $5 billion sum, but they've got this thing in a clock so that you get a stat, and I never was given the time, which I knew if I had the time I would be able to make a much better recovery. All the more reason for me to want it, as possible, to work closely with victims and their representatives, whether independents or whether they're in a party action, to help them have access to the intelligence as best as possible or legally possible in terms of asset identity. And that could be done at the time of sentencing as well, working through their representatives there. And then transparency and anonymity, that's another paradox. You know, we're in this age of, you know, we say complete transparency, this incredible information, and yet we're cutting deals left and right so that nobody's dragged through the mud. You know, is justice really served if things aren't being played out and allowed for the potential of a larger sum to be acquired? It's like a fast-track system. I remember our office was doing this sort of thing with healthcare fraud cases, you know. They were settling them left and right, happy with $4 million or $5 million when each fraudster was taking over $100 million and sending it to Spain. So that's the very simple message I wanted to leave with you today, is that there are multiple mechanisms that we all know about and utilize, but not very effectively. So we don't have to reinvent the wheel. We just have to look at the tools that we have and reconsider how effectively we put them together. So that's it. So if any questions?
Africa, do you have any examples from Africa at all, or any experience in Africa We don't hear much about it.
Well, I mean, we're interested in Africa in terms of the new payment systems that they're using there, obviously. What we're doing in Africa is more intelligence related and terrorist financing related, which we don't talk about, but we're very involved in Africa. My former company, very involved in Africa in that respect. And then the Nigerian frauds, obviously, are just so egregious and large, and there's not, and because of the situation with the governments there and the corruption there, it's not on the radar as far as working criminal actions. The FBI in general has switched its whole focus on intelligence gathering more so than criminal prosecutions, and I'm just one of many who have been critical of that philosophy, because the best way, all investigators' approach is to you gather intelligence by arresting people and having them face stiff sentences, and that's how you get really good intelligence. So I think that the new director of the Bureau is swinging the pendulum back to where there's more emphasis on criminal investigations, because it's so productive in terms of good terrorist intelligence. So.
I think you mentioned that there was one example of the government and the private sector that you perceive were working well together. Can you expand on that a little bit better? And
I worked a case. I worked a case just a couple of years ago. The subject's name is Claudio Osorio, involving the earthquake Haiti fraud. And Osorio was responsible for a great idea. I don't know if he was the architect or somebody was, I don't know if you heard about it, but building these quick makeshift huts that would house all the victims in Haiti. And there were a lot of major investors in this project. I think there were major sport, one of the main, I think Alonzo Mourning might have been a victim in the case, in fact. So the trustee, we were working closely with the trustee in that case. They had a heads up in a certain direction, and we had one in another direction, and we were working actually and sharing information on who was going to be the first to be able to attack certain funds overseas. So there was never a situation there where we were concerned about who was going to prevail there. And I think it may go to the personalities and the philosophies of the attorneys. The attorneys set the tone pretty much on how, but it is an example of that. It happened. It's happened, and it was a successful case, and it was given to the receiver pretty much, mostly, and including the few accounts that we took. I think there was 2 accounts that we just forfeited, and then the remainder we gave to the receiver to finish up on his end.
Is it a struggle mainly competing for the asset?
Well, I think the government does have responsibility not to lay down on what they easily have, because it is going to remove a portion of the monies to what's available to the victims for what the receiver is entitled to for his work. So that's the dominating reason why. Not to mention being accredited for doing your forfeiture work well. But there are a lot of attorneys who don't really care about that. There are a lot of agents who don't care about getting credit for that. And there are those where forfeiture is really important to them and they don't want to hand it up too easy. And I think we should show that we're doing what we're doing, and I think it just naturally falls out. There are certain things that they're better at reaching than we are. And they can do it for longer than we can. And we have to have our shop wrapped up by the time of sentencing. They don't. There's also tax recoveries, things that neither of us can reach, but that revenue agents can get at some point in time, whether we were able to make a tracing or not, or we weren't able to restrain because it wasn't substitute assets that we identify. We're not allowed to restrain. We can name them, but we can't restrain them. So if for some reason the trustee wasn't able to reach them, in that case, a revenue agent perhaps would be able to get it. But I think just organically it's going to fall case by case in a different way, in a different combination. But I would encourage not to be fearful of the government, and the government should not be fearful of private, attorney actions in its efforts to recover funds. I think it's a misnomer to think that there's something, scary there that's going to hurt you, by doing so. I'm not going to be able to talk about this very often because eventually I'm going to get a little more experience on the private side, but while it's all fresh in my mind from my days, many years doing this, I wanted to share what I, from a government perspective, how things ought to be looked at from the private side. They're not the enemy. Darren?
Yeah, thanks. Chris, really good session. Thank you very much. You touched upon FinCEN and Section 311 Capture Act.
Yes.
And the law about one of my clients has had the same lawsuit against us, so it's effectively put them out of business at the moment. Is this a new tool that's going to be used more in prison, do you think? And what kind of the allegations of my client are being highly vigorous? What kind of safeguards?
Your client, how's your client involved?
The bank in Cyprus. So the bank has been under Section 311.
Independent of the action and totally separate 311? Oh, okay. Yeah.
And they're defending vigorously. But is this an increasing tool to be used by the US?
Well, I think they want to send a message. I mean, obviously they're using high-profile money launderers as an example. Cyprus is another sore spot. Cyprus is just asking for it, So I can understand the action there. I'm at a lack to understand what its recovery capabilities are, other than suspending. And again, it takes, it's one thing to recommend what 311 does, but it still has to be put into the register. It has to be, the Congress has to back the action to remove its access to the United States. So it's something where the banking community has been very fearful of the repercussions of the United States coming on too hard. But on the other hand, the inaction, when you consider the level of criminally sponsored governments on the rise, I don't know what the United States is supposed to do. Until it's too late, the United States isn't even able, capable to do anything. So I think it's certainly a symbolic, heavy-handed nuclear weapon. I mean, it really is. Something has to be used sparingly. So I don't think they're going to start shoveling them out everywhere. But you're looking at two countries sponsoring unmonitored, third-party, bottlenecked, hundreds of billions of dollars movement of illegal money. That built within there are frauds of no end. You know what I'm saying? I mean, it's just incredible. Drug money combined with all other kinds of money, Capital flight, countries, people having nothing left because, talk about Nigeria. I mean, in Africa, I mean, basically that's what's happening is this funneling of the resources of entire countries to a few select people. So before the United States doesn't have a leg to stand on ethically, which it may still have something, it needs to do, I'm a supporter of the usage of 311, so. But I wasn't familiar that it was executed in Cyprus.
The bank's actually headquartered in the bank in Tanzania. So
yeah. Well, you know what I think? I mean, I think that the terrorist financing money is going more mainstream into third-party money launderers, whether they're Muslims or not. I think their money's been sufficiently through, trade-based money laundering and other methods that are in Africa extensively, mostly, including South Africa. The money, you're looking at the ease to justify a 311 action when that terrorist word pops in there. And by the way, most of the usages of 91K to date, which was designed for terrorist actions, are really not terrorism at all. They're being used mostly for major money laundering violations. Which, not to say that there isn't a terrorism one that is hiding in there and they don't want to bring it out in the open, but just technically, if you were to look, there may have been one that was used for, terrorist-related associated use. So.
Backing on the same question somewhat, because is there a sort of standard by which the FBI using to determine whether it's going to actually use a Section 311, or what's the process? Because I mean, although we're talking about banks
Sure.
that are doing wholesale money laundering, supporting the fraudsters, I mean, there are some big mainstream banks that have been fined, for equally egregious behavior, but it seems.
Why? Yeah.
An unkind person would say that the bigger banks get fined and then smaller banks potentially for similar behavior could have the 311. So I'm just interested in the thinking in the process behind the determination of what course of action would be used in doing the 311.
I'm interested in it too. But thank you for bringing out, which was one of the themes of the talk, is that you got to clean your own house first. You got to be fair. And I am criticizing the use of heavy fines as a way to move on, make it go away. I'll tell you that the victim in my 981K action with Banca Privata d'Andorra was JP Morgan Chase. And you know how they got their money back? To spite us, they went, well, I don't know if it's my personal opinion or maybe there is a legal reason, but they wouldn't go through the United States to do it. I had to facilitate an Interpol action to get the bank's money returned. And the only reason why they did it was because it was JP Morgan Chase. They didn't want to have a problem with JP Morgan Chase. The other victims in the other cases that were parked for 981Ks didn't get a dime. So they're the losers in the 311, okay? So what was the more effective action? Maybe the 311 isn't the answer, maybe the way to hurt it really. Because you open up shop, right? You close down a boiler room, what does it do? It pops up somewhere else. Banks can do the same thing. Hurt them by taking their money, take billions of dollars from them and take it and look at the criminal liability. I mean, and that's where the bloggers, can do a lot. A person working in the government, even former. I mean, you have to be really careful what you say. But the bloggers, they can do it, and they can point it out and call them, make them respond, Any other questions? Well, thanks very much. Appreciate it.